Thanks very much for being with us. This is the latest in our On the Issues series, and today's guest is Dean Strang. Many of you know him as one of the two primary defense attorneys for Steven Avery. So let's welcome him to Marquette Law School. I don't know that I really need to do this. I guess we ought to spend just a moment or two on the Steven Avery case just to set the background here, as probably just about everybody in this room knows. Steven Avery's case was very well publicized back in the mid-'80s. He was convicted of a sexual assault. He served 18 years in prison. The Wisconsin Innocence Project came up with evidence that proved that Steven Avery did not commit that sexual assault, and he was freed from prison. Then a little bit more than 2 years later, he was charged with killing Teresa Halbach. That case went to trial, and last spring, I think back in the month of March, he was found guilty of killing Teresa Halbach. Dean Strang played an instrumental role in this case as a defense attorney for Steven Avery, and we're not going to retry the case today, but we are going to spend some time on the environment that surrounded the case and cases of this kind, the media environment specifically. And I'd like to begin there. Let's talk about what it was like as someone in the middle of this case. How would you describe the media environment for the Avery case?
Well, let me start by saying that I, and then very shortly after me, Jerry Buting, my co-counsel, did come in to the middle of the case. Right. Steven Avery originally was represented by two assistant state public defenders here, settled the civil claim he had pending against Manitowoc County from the 1985 conviction.
The wrongful conviction. Mm-hmm.
No longer was indigent and retained me and Jerry. So we came in, I came in on Valentine's Day of '06, and so that was 2-3 months after he had been, about 3 months, I think, after he'd been arrested and charged. And by then, the media were just omnipresent. I don't know a better way to describe it. But they were everywhere, particularly the Green Bay media market, although this case also drew attention even at fairly routine pretrial hearings from the Milwaukee media market. Not so much from Madison or Wausau or Dubuque Superior, the western part of the state, not so much at all, but along the lakeshore, it just drew intense media coverage, even for minor proceedings. So it was different in scope than any case I previously had been involved in, with the only one coming close being something that everybody called the Dairy Princess case up in Wausau in the late 80s. So it's different in scope and also in sweep of the media, in the sense, Mike, that we had you had TV and radio and the newspapers, of course, but then you also had bloggers and you had streaming video being put out over websites. So there was just a broader sweep of media involved than any case in which I had been a participant before.
So this was a new experience for you, particularly the live blogging that was done, the streaming on the internet of video directly from the case. Did that new media present new challenges for you as a defense attorney?
The new media did, and the composite of the media coverage did as well. It was the first time in trying a case that I had been asked to wear a lavalier mic, on my tie, for example.
How were you with that, incidentally?
Very clumsy at first, and I got a little better as time went. But the new media in particular, I'm not a Luddite, but I'm something sort of close to that in terms of my comfort with the digital age and internet-based media. And so I really had to adjust my thinking to the idea of, for example, streaming video on a website where there's no off, there's no editing. It's just going out raw. So if you have your suit jacket off and you're, sharing a light moment, punching the prosecutor in the arm or something, and that's potentially going out to the public in a way that CBS affiliate, the NBC affiliate, whatever, they won't. They're going to trim. That really did take some awareness that I didn't have at the beginning.
You said there were instances where sidebars were being essentially televised, broadcast, because what? The people doing the broadcasting didn't understand the rules, or what?
We had a little bit of that, and probably a little bit of not caring much about the rules. But I mean, to start with understanding the rules in the first place, I mean, I don't know how many of you are lawyers or law students, but the Wisconsin Supreme Court, probably like the highest court in most states, has rules on media coverage, and they're codified in Chapter 61 of our Supreme Court rules. And if we're talking about the NBC affiliate or the Fox affiliate or CBS or larger radio stations that regularly may cover court proceedings, you can rely on the producer or the reporter even sort of understanding what the parameters of permissible broadcast are. When you have somebody who may be working with a webcam, you can't rely on them knowing the rules or much caring about them. And there's less investment, I think, in the rules by some of the new media or the internet-based media, because they're not going to be repeat players in this county or in front of this judge.
They're just there for that one trial.
They're there for one trial, period. Whereas if it's the Fox affiliate in Green Bay, they're all going to be down covering another Manitowoc County case someday, if we want to, stick with the Avery case as the template here. I mean, they're going to be back in front of this judge, or in this county at least, dealing with this county's media coordinator. So there's some investment in the personal relationships and in what people think of the objectivity or responsibility of that media outlet that you don't necessarily get with a blogger or somebody who's just running a feed to a website.
Did you express your concern to the judge during the trial?
We didn't have to. In the Avery trial, we had a judge who was very much on the ball, very much aware of all the different challenges he faced, and he did a pretty good job of policing the Supreme Court rules and working with the media. He also was pretty good about telling the parties later what contact he had with a lawyer for a TV station or with media representatives. Not all judges will do that. I mean, the media aren't parties to the case, so the district attorney and the defense lawyer don't necessarily have to be told what contacts the judge is having with the media, but Judge Willis in Avery was really very courteous, I guess, would be the easiest way to describe it, about communicating fully with all of us so that, we sort of knew what was going on.
Knowing what was happening in there, and knowing there were times where perhaps things that weren't supposed to be broadcast were being broadcast, I'm not going to ask you to divulge your conversations with your client, but when you know things like that, what do you tell a client, knowing that you've got to be on, I don't want to say on guard, but you've got to be respectful of the fact that you could be essentially on broadcast at any moment? Oh,
you are. I mean, in essence, you've got to tell a client, whether this is a criminal trial or a civil trial, you're on candid camera. I mean, he is. And, new issues arise, particularly in a criminal case. One that Jerry and I wrestled with, and I thought, came up with a fairly obvious solution, but nonetheless one that was innovative in terms of addressing a new problem, is jail garb. We had a client who was in custody, not out on bail, and the rules of American justice are that when there's a jury in the box, the client shouldn't be in identifiable jail garb. There's a prejudice, or a suggestion of guilt, obviously, that comes in being in a jail jumpsuit in front of your fact finders. In the mine run case, the way you deal with that is just to have mom bring some civilian clothing, some street clothing for him for the jury trial. And the sheriffs let him put it on in the jail or the bullpen, and he comes out and he's in civilian clothing, and then the jury comes in and you don't see shackles, you don't see jail garb. Well, in this case, where we could have a 15-minute status conference and you've got every media outlet in the eastern half of the state covering it, the public is getting lots and lots of hits or images of your client in obvious jail garb or walking shackled in jail garb. And Jerry and I got uptight about this very quickly, because we realized the number of media exposures the jury pool was getting to the client being treated like a very dangerous guy. And the jail jumpsuits that the Calumet County happens to use are made him look like he had jumped off the Monopoly board. They were these horizontal white and black stripes. It was, the Monopoly board get out of jail guy, or an Edward G. Robinson movie or something. It was just a cartoonish, a caricatured sort of jail outfit. And so the way we addressed that was to reach an agreement with the judge very, very early after we got in, that for any court appearance, the client would be allowed to appear in civilian clothing. That helped. It ameliorated the problem. It didn't remove it, because, the compulsively, really compulsively in the psychological sense, the TV stations like to shoot what they call B-roll, of a perp walk, where they film your client being walked down the hall in the handcuffs anyway. Over and over they love to do this. But it did help to have the client in civilian clothing, but that's not a problem that had arisen for me before at a routine status conference.
Did you read any of, for example, the live blogging that was done during the trial?
I did.
What was your reaction to it?
Boy, you could get sucked into it and waste an awful lot of time when you're in trial. But what Jerry and I decided is that up to a point, if we could discipline ourselves, blogs or posts, comments posted on websites or on newspaper websites, websites that were streaming the case, courttv.com, for example, that up to a point, blog entries and posted comments gave us something of a surrogate jury, a mock jury. We got some sense of what people, the listener, was understanding, what they were rejecting of the defense theory, what seemed to resonate, at least with this, this particular audience.
It's almost like a focus group for you.
An unfocused focus group, or maybe an unfocused group. It's, you have to be very disciplined, I guess, is as good a word as any, about how much time you're going to commit to that when you realize that, in a case like Avery, some of some of the posts you're reading may be from someone in Manchester, England, or, you know, that you're really, the illusion that you're seeing a cross-section of the world or the United States or eastern Wisconsin is exactly that, an illusion. I think it's actually a fairly small demographic who spend their day at 2 o'clock in the afternoon watching a trial in which they have no personal stake, streaming on their laptop, and then, you know, and furiously commenting on it. Because when you start to read the posts, gosh, it turns out that there are about 7 people who are, you know, posting 90% of what you're reading. But up to a point, it worked as a focus group as long as you had the discipline not to have it gobble up all your time.
You know, when cameras came into the courtroom back in the late 70s, there were a lot of concerns about how it would change the dynamics of the trial process, and there were some moments where I think people in the journalism business weren't exactly sure how to do this because it had never been done before. Are we really just going through that with new media? Are there bound to be these sort of bumps in the road, and down the road, is it really not the same argument that was made with cameras in the courts, that this is a good thing because it helps educate the public as to how the legal process works, and it demystifies the legal process? Are we just maybe at a different point in our history, and it's kind of the same thing happening again?
In my view, the answer to your first question certainly is yes. It's a little bit different bumps in the road, but it is just bumps in the road. It's adjusting to changes in technology and changes in traditional ways of doing things. So just as in the 1980s, issues were, you know, could television cameras operate just on the courtroom lighting, or did artificial lighting have to be introduced? Issues were still cameras and the shutter clicking. Issues were cords running all over the courtroom, or picking up sound, and how intrusive were microphones. You know, and we worked through all those issues, all those problems. Well, now the bumps, as I say, are a little bit different because the technology makes the media less intrusive to an extent. Still cameras are all but a thing of the past in a courtroom. You know, you may have one, and they're very quiet these days. It's a digital camera anyway. You know, a tiny camera, you know, something this big, can be mounted under a table or on a swivel on the ceiling, rather than having a full-size, you know, old-fashioned television camera. So it's less intrusive, but one needs to be more aware. And the cues to be aware are not there. You're not hearing the shutter clicking. You're not seeing, you know, the bank of camera people standing there. So it is just an adjustment. Now, in terms of whether this expansion of public access into the courtroom is good on balance or not, this divides people by really fundamental personality types, I think, or fundamental views of the world. And I guess I come down in saying that on balance, it's probably good in that it does increase public access. One of the wonderful things about the new media is how low the economic barriers to entry have come. You know, if you've got a webcam and a laptop, you can go blog a trial, assuming you can get a seat in the trial. You don't need to own a newspaper anymore. That to me, in terms of my populist impulses, is a terrific thing. On the other hand, you know, as someone who spent the 5 years right before Avery working as the federal defender in Wisconsin, and in federal courts, there are no cameras allowed period, of any kind. So we're in federal court, you're still talking about chalk artists, pastel artists on paper, if they cover it at all. Something lovely is lost, as it always is when anything is demystified. Something really lovely and sweet and useful, in a sense, is lost. When the unblinking eye of the camera is catching everything.
I want you to expand on that. When you say something sweet, the mystery of what happens in court, or that's a positive thing?
There is. I mean, how would your marriage look if there were a webcam running in your bedroom all the time, It would look a heck of a lot different than the marriage you present to your grandchildren or your children. I mean, to the extent that, the grandeur of the courts is good for the public perception of the administration of justice, to the extent that the depersonification of the judge is a good thing, so that we have the sense of an impartial arbiter, someone who's not a human being, but rather is a black robe and an administrator of justice. To the extent that that's lost, when you find out that the judge really does have a runny nose, or doesn't like this lawyer or that lawyer very much, to the extent that that goes by the wayside, and people see the system as flawed and terribly human, which of course it is, in truth, something's gained and something too is lost.
So you're somewhat ambivalent about this at this point.
I am.
Yeah.
I mean, there are, if you asked the public, if you could somehow poll the American public on the esteem in which they hold federal courts as compared to the esteem in which they hold state courts, my guess is that the visibility, the media access to the state courts would reduce somewhat if we could measure it, the esteem in which these are held. I mean, how many of you thought better of the administration of justice in California after watching 4 months of Judge Ito? I didn't, and I'm a lawyer. I understand judges are human, and they get things right and wrong, and they have temper tantrums like the rest of us. But as I say, there's the unvarnished quality that we get from widespread media access is a good, but something of the grandeur and the impressiveness of the process can be lost.
Quick question about the Avery case. You just mentioned the O.J. Simpson trial. When you look back on it, were you satisfied with the decorum at the Avery trial? Were you satisfied with the way the major players in that trial conducted themselves?
Yes, I really was, including the media, who were major players in that trial. But we got lucky in the Avery case in that we had just an exceptionally diligent judge with an exceptionally good temperament for trying a lawsuit under pressure. We had highly skilled and highly professional prosecutors in that case. We had 2 defense lawyers who each came in with prior experience being on camera in a trial. We had a courtroom that was set up for the media, had a media room at the back with a window, so that the media didn't occupy all the public seats, and spectators and the jury weren't distracted much by the media presence. So a lot of things worked well there, and I came away thinking that the decorum of that particular trial was pretty good. Now, I didn't watch it from the outside, and people may have a different opinion of that than do I as a participant.
Mm-hmm. I want to spend just a moment on something that is also a part of the world we live in today, and that's jury selection. And you and I were talking about this before we came into the room. One of the interesting things about jury selection is when you're trying to find that pool of jurors, now you may have to take into consideration what, for example, those potential jurors have written on their blogs or on their MySpace site or their Facebook site or whatever.
Right.
How much of an issue is that becoming in terms of selecting a good, solid jury?
I think there are two issues, and I'll unbundle them, and they're both big, in my view. One is what are your jurors being exposed to, and we've been discussing that before the trial. What's that jury pool seeing? But it goes well beyond, with the new media, it goes well beyond just what they happen to see on the 5 o'clock news or the 10 o'clock news. We're now talking about if they're assiduous readers of blogs or newspapers on the internet. We're talking about the ability to click a witness's name and go to his CCAP record. Click the defendant and look him up on CCAP. Go to Google Earth and do a virtual jury view of the scene of the crime, or the scene of the supposed crime. There's so much armchair access to information that you didn't have to worry about jurors having or finding in the past, that you need to explore this in jury selection. The other stick in the bundle here is the one you just brought up, which is what are the jurors themselves saying or doing, or prospective jurors saying or doing. Because they have a MySpace profile, they have a Facebook page, they're on Twitter, they're doing whatever it is they're doing out there. Some of them almost because they've got an exhibitionist tendency, and some of them because they're longing to express themselves somehow in writing. And they're out there talking. I've got a good friend who's a lawyer, happens to be a lawyer here in Milwaukee, Ann Willis-Reed, who runs a great blog on juries called Deliberations. And Ann has gotten interested lately, in the last month or so, in finding jurors who are blogging. Maybe blogging about the trial they're then sitting on, okay? Or they're now on a jury, but they've been blogging. And this is something you probably want to know, because the civil discourse that we've developed in the English we use for formal correspondence, dear Mr. Goucher, your letter of the 15th received and noted, thank you for writing, blah, blah, blah.
To be honest, most of the correspondence I got didn't follow those lines. It's a little harsher in tone than that, but...
but we spent 500 or 600 or whatever years with English developing a stylized form of communication so that in writing a letter to someone, we didn't offend if no offense was intended. All of that form of civil discourse is gone, really, in the blogosphere. It's very unfiltered.
She gave a very blunt example in her
Ann did in her blog, but you go online and look at this stuff. It's very unfiltered. People are posting pictures of themselves in their underwear, or making blog entries on what they bought at the grocery store yesterday. It's very strange. And if you can find out what your prospective jurors are saying online, that's useful information to have in terms of piecing together a fragmentary sense of what their attitudes may be. I don't know if any of you caught this or were aware of it, but do you know about the lead paint trial going on right now in Milwaukee County Circuit Court? Civil case. a class of plaintiffs suing the lead paint manufacturers. Big trial going on right now. One of the prospective jurors was Twittering during jury selection and got caught. I mean, or Judge Sankovitz asked. And sure enough, he was Twittering on his cell phone. People know what Twitter.com is. It's essentially a blog community blog in text message form. Sort of 4 million people answering the question, "What are you doing right now?" And their slogan is something like that. So, I'm in Stockholm ordering a latte. I'm in Hoboken, I'm about to go to bed. I'm in Nairobi, and I'm digging a ditch.
I'm in the Milwaukee County Courthouse.
I'm in the Milwaukee County Courthouse.
Yeah.
I'm on jury duty, and oh my God, I hope they don't select me. Arg, this is so boring. Please, please, please strike me. And I mean, I'm paraphrasing, but this prospective juror was sending some of this stuff on his BlackBerry or his cell phone or whatever he was texting on there in the courtroom. And he got asked, and he had to disclose it. And the lawyers all went and saw it and read what he'd been writing. Well, he's probably not on this jury.
If you have to investigate, though, the writings of jurors, I mean, you're talking about jury selection processes that are going to go forever. I mean, that, it becomes a very, very extended process, I would think.
It's impossible to do in some ways. But what it tells trial lawyers and judges is you ought to think about designing jury questionnaires that ask jurors. If I were to go on the internet, where could I find something that you have written or that you have posted? What 10 websites do you visit most frequently? Or whatever the questionnaires would be. And in the actual voir dire process or jury selection process, when lawyers are on their feet in court with the jury panel there, you have to think about asking questions to get at this, because it's culturally pervasive, particularly, I think, for people under 30.
Younger jurors, yeah. I'm going to stop there, and we'll take your questions since we have a lot of attorneys and future attorneys in this room. So if you have any questions for Dean Strang, raise your hand, maybe say who you are, and then ask away. Any questions? Right here.
I'm Emma Zimmerman. I'm a 3L here at Marquette, and I remember listening to Jeffrey Dahmer's defense attorney back in the early 90s at UW, and I'm wondering how you keep your skin so thick all the time and yet don't get discouraged in your profession.
I don't. I get cut from time to time, and B, sometimes I get discouraged. And a good way to do that is to go on the internet and read what people are posting about you. Everything from he's whiny to I don't like his haircut to to they ought to fry his client now. Why are we wasting the money to try the client? But I mean, I guess it's like anything else where momentarily you step into some level of public visibility. You have to adjust to it and figure out a way to let it roll off your back. And the best way is usually to turn the computer or the TV off. But I have resisted, for example, so far getting an unlisted telephone number. But some of the experience of the Avery trial causes you to ask yourself that question again.
Did you get death threats during the trial?
I didn't get any death threats. I didn't get any death threats this time. And I have in the past, not serious ones, but it doesn't have to be a death threat when the phone rings at 1 a.m. and it's an angry stranger. It doesn't have to be a death threat. It's just disturbing, and if I think it's disturbing, ask your wife what she thinks about it, or your kids if you have kids. So, you try to toughen up, and fortunately for me, I'm really not a public figure. And Avery lasted 7 weeks, and yes, you'd get recognized in restaurants up in Appleton during that time, but I could go to a restaurant in Appleton now and nobody would know who the hell I am, which is just the way I like it.
Mm-hmm. More questions? Yes, sir.
Could you comment from a contemporary perspective, the positives and negatives on the federal sentencing guidelines?
Sure. Contemporary meaning as we sit here today?
As they have been interpreted and are employed today, yes, as opposed to when they are initiated.
Oh, I don't know if you're a planter or not, but I was one of the lawyers on the U.S. Supreme Court decision that invalidated the mandatory quality of the federal guidelines. But with that disclaimer that I was one of Booker's lawyers in the Supreme Court, I think that the mandatory federal sentencing guidelines never were a good thing. That a distrust of judges is fundamentally a distrust of judging and a distrust of the judicial branch, and that if we hope to have any individualized edge to the administration of justice, the discretion has to rest with the judge and not with the prosecutor, which functionally is where the legislature put the discretion with mandatory sentencing guidelines. My personal opinion. The reason to have guidelines, whether they're advisory or mandatory, is to try to get some equity in sentencing, to reduce unwarranted disparities in sentencing like offenders for like crimes. And used in an advisory way and used intelligently, guidelines can be very good at smoothing out some of the unreasonable disparities that you'll see in sentencing. That's probably particularly important in federal court, where you'd like to think that a kilo of cocaine in Miami with somebody who's 25 and has no prior record gets sentenced about like a kilo of cocaine in Rapid City, South Dakota with somebody who's 25 and has no record. But the reality before the sentencing guidelines in federal court is that there were significant geographical disparities. There also are even more significant racial disparities in sentencing, socioeconomic disparities in sentencing. And used intelligently in an advisory way, I think sentencing guidelines at the federal level or even at the more local, the state level, cannot eliminate unjustifiable disparity, but they can reduce it. One man's opinion.
More questions? Yeah, Dan.
Dean, you just described your experience in the Avery case last spring. You were just involved in a high-profile murder case in Dane County. How, if at all, did your experience in Avery shape your thinking about jury selection or trial strategy in this more recent homicide? And maybe just want to give a brief background about what that case was.
Yeah, Steve Hurley and I just defended a gentleman in Dane County with Madison in an old first-degree murder case. His wife, who then was divorcing him, disappeared in 1976, and in 2006 he was charged with murdering her, although no trace of her has ever been found. She simply hasn't been heard from since October 1976. And I went in, I think, viewing that case through the prism of Avery, not surprisingly, since I was, trying them 6 months apart. I think, though, unfortunately, didn't apply very well in jury selection the lessons I've drawn from Avery. Now, part of that, though, was just the mechanics of how jury selection ran in the most recent case, which points up, I think, probably the best answer, which is, judges are not yet attuned to the problems of intensive media coverage in the information age, in the digital age. And if we want judges to accommodate the changes or the availability of more information about jurors, we've got to ask the judge to do that well in advance. Got to propose a questionnaire some months before the trial, or find a time at a status conference or a pretrial hearing to have a discussion with the judge about the sort of topics we've covered here today. That murder trial also was interesting because for no reason apparent to me, it got next to no coverage. The occasional one camera in the media room off the side of the courtroom. Far as I could tell, no blogging, no live streaming video. I don't know. It was interesting. How often do you see a 30-year-old homicide case charged where they don't have a body? I thought it was sort of interesting.
You didn't miss the media coverage.
I didn't miss it.
Yeah. Mm-hmm.
I didn't miss it. But you talked about mysteries, Mike. One of the things that remains cloaked to me is why these reporters pick up and feed on the things they do and not other things.
Mm-hmm.
That's a big topic. We don't have to go there.
I'm Mike Donahue. I teach in the history department here at Marquette. I'm just wondering, I realize the technology's new, but how much of this is really new? I'm thinking about celebrated cases like the Stanford White case, Leopold, Sacco and Vanzetti, the Scopes Monkey trial, tremendous breakdowns in the rules of jurisprudence. We've got cases where the judge's chauffeur is leaking information to the press, fellow prisoners are leaking information about the defendant, jail guards, court clerks, in these real media circus kind of trials, you have a lot of breakdowns.
You do, and we could add Sam Shepard's trial in the late 50s to this. But let's take Leopold and Loeb. It's 1924. It's the summer. It's a quiet time at that point in American history in terms of media events. And I think Judge Caverly there was the first judge ever to allow radio broadcast of closing arguments. Clarence Darrow pled the two defendants guilty on the first day of trial, and then they spent the entire summer doing a sentencing hearing in Leopold and Loeb when he tried and ultimately was successful in saving their lives. But you had in that courtroom a bank of huge radio microphones, because these things were big at the time, right? And what's the I forget the word for the annunciator, is that the collar that used to go around the radio mic? You had really a real distraction going on in that courtroom in the summer of 1924. Did it diminish the quality of justice? I don't know. But what it surely did is got the lawyers on both sides. District attorney was a guy named Robert Crow, and Clarence Darrow was for the defense. You had the lawyers and the judge playing to the microphone. And that's timeless. That still goes on. Now, I'm of the opinion that in a notorious criminal case, if I'm defending the accused, I'm better off with the judge playing to the microphone. I'm better off because the judge wants to look impartial, wants to look judicious as well as judicial. And my anecdotal personal experience has been that it levels the playing field somewhat for the criminal defendant when there's a lot of publicity. I don't know. I mean, Scopes, which was a contrived sort of farce from the beginning, in the year after Leopold and Loeb in the summer of 1925, Scopes was not a successful trial. It was a successful bit of theater. but it wasn't a successful trial, and it was a test case from the beginning where the maximum fine was $100 when John Scopes got convicted of teaching, Darwin's theory of evolution. But you wouldn't commend the Scopes trial to anyone as a good way to allow the media to participate in a real criminal case.
One just final point, I think a legal historian said that the O.J. Simpson trial, wrote an article in which he said, by my count, this is the 67th trial of the century.
That's exactly right, and H.L. Mencken was calling the Scopes trial the trial of the century in 1925. Well, as you say, there probably were 66 after that.
More questions? Yes, Dean.
As a defense attorney, do you imagine new strategies that prosecutors are going to use using new media to their own advantage? In other words, you've talked a lot about trying to protect your own clients, your clients' interests, but what do you imagine being mobilized against you in the new media?
I don't have to imagine much. In Avery, you all may remember that he had a 16-year-old nephew who comes forward, and the police get the nephew to give statements about 4 months after Mr. Avery was charged. And what the prosecutors did when they charged, the day before they charged the nephew and the day they charged the nephew, if I recall right, first couple of days of March 2006, what they did was hold daytime news conferences that in Green Bay preempted local programming. So, Days of Our Lives or whatever it was got kicked off the air for 45, 50-minute news conference, one of which the prosecutor introduced by slapping an R rating on it, saying, I don't want young children or friends or relatives of Ms. Halbach to watch this because of the graphic content that will follow. Well, what did that cause every 14-year-old to do? Turn up the volume, and everybody else.
And most stations ran it too. I mean,
Absolutely.
Our station ran it.
Absolutely. And then what he proceeded to do was give a very effective opening statement by just presenting in dramatic fashion the allegations in his criminal complaint. Now, here we are. How many hundreds of thousands of people have heard a gripping, horrifying, chilling opening statement in a murder prosecution, and it's 11 months before I'm going to get to give my opening statement?
Could you imagine, for example, a prosecutor, and that's a great example, could you imagine prosecutors trying to plant things in YouTube or in blogs with the understanding that more and more of that material then gets picked up and makes its way into the mainstream?
I can't at this point fathom ethical prosecutors or defense lawyers, for that matter, trying the case through YouTube. But as soon as those words are out of my mouth, I suppose somewhere it's going to happen. The new media and the new places to communicate to the public don't change the rules of professional conduct for lawyers, obviously. We have to be more attuned, if anything, to what we're saying and how it may influence a future fact finder in a case. So I hope the answer to that is that no, it won't make much of a change in the behavior of prosecutors or defense lawyers or civil lawyers, for that matter, in content. But in terms of the media they choose to present the content that's allowable, yeah, it may affect how we conduct ourselves before and during a trial.
Do you think, given the new technology, we need new guidelines of what is acceptable in terms of media broadcast? And by broadcast, I use that in a kind of a very large context. Do we need new guidelines or updated guidelines?
For the media or for
Yeah,
lawyers?
for the media. For the media.
The media. This is something you and I have talked about before, and I really think that I haven't thought this through enough to come up with an intelligent answer to that. I really am still puzzling about that. Is this old wine in new bottles, or is it new wine? And I'm not there in having an answer, so I guess I'm punting. But you know, if you want candor, I think that's a real interesting question, and something on which I would like to hear thoughtful people from the media, from the academy, from the bar, sort of get together and brainstorm.
Yes.
Do you think that new media coverage perhaps inadvertently stacks the deck in favor of the prosecution? I can think of two recent cases, the Family Secrets trial in Chicago, where on the front page of the Chicago Tribune online and the Sun-Times, they linked out to the transcripts of jailhouse recordings, photos, all this evidence. I shouldn't say evidence, because it may not have been admitted in trial, but the Department of Justice had made this public. And so whenever anyone's going to look for that information, they have, I guess you would say, the prosecution side with no place for rebuttal. In the Dassey trial, I think the Green Bay paper actually had, I thought, very impressive interactive features, from maps of the farm to the background on DNA, but it was that traditional media assessment of this is what DNA is. And what people may try to raise at trial is, that may be what DNA is, but this isn't what we've got. And again, on that front page or that splash page, the defense doesn't always have that opportunity to address those issues, and you have to wait for trial. But every time somebody goes there, they're presented with that opening statement 11 months in advance.
The nature of the new media, I think, do give the prosecution some advantages practically. The inadmissible may become available to the public and widely known, although legally inadmissible. But by the same token, and I don't know how this balances out, there are also potential advantages to the defense in a criminal case. I already mentioned one that I see as an advantage, which is the glare of publicity on balance causes judges to act like judges. I'm better off when the judge is acting like a judge, not like a second prosecutor. And a television camera rolling helps encourage her to do that, or him. Moreover, in the new media, you don't have the either conceit or perhaps deceit of objectivity. It's Tom Paine all over again. You know, objectivity is not held as a cardinal value by the bloggers, for example. Opinion is. Putting myself forward, sometimes almost in an exhibitionist way, but certainly you've got a much more vibrant marketplace of ideas, if you want to use a hackneyed term, with the new media, because the economic entry barriers are so low. And, you know, across that spectrum, you're probably going to get some skeptics of the prosecution version, just as you're going to get some adherents to the prosecution version. You know, you'll splay people out across the range of possible opinion. Now, how it all balances, I suppose, depends some on the case and some on how adept the lawyers or the parties or the police, you know, whoever may seek to manipulate the information available to the public is at, manipulating is a loaded word, but at tendering information and getting that out through the various channels available now.
Mm-hmm. One or two final questions. Anybody? Yes?
in demystifying the legal experiences you kind of mentioned a little earlier, you said it might affect the esteem individuals hold courts to. Could you speak a little bit to how that would negatively affect the whole legal process or the legal system? You were a little ambivalent about it. Is there the possibility that that demystification negatively affects non-federal courts, and how would it do that?
I don't think we want a nation of amateur legal realists, of citizens who think that cases get decided the way they do because of what the judge had for breakfast, in a sense. I think there's something valuable as a matter of inculcation of shared values in the public seeing institutions as not personalized and as fulfilling grand and important roles. You know, is there some legerdemain in that? Some dishonesty? Yes. But there always has been, in a sense. And, you know, this is a conversation that people have, and it's a good thing for people to think about, because, you know, where I've heard it arise is in contemplations about the fact that FDR's polio couldn't go unknown to the public today. You know, we would see a president who needed assistance to stand rather than a strong figure standing and leading us through World War II. Kennedy's peccadillos in the White House couldn't go unknown today. So, you know, it probably wasn't Camelot, but something's lost when the appearance of Camelot is destroyed. We become more cynical. We become more convinced of the pure personalization of our public institutions in a way that ultimately may be misleading, because, you know, every once in a while a judge really does try to decide an issue on what he or she thinks is right, rather than, you know, some predilection the judge brings to the problem. That's pretty fuzzy stuff, but it's a legitimate conversation to have, because there are some intangible losses along with the visible, tangible gains.
Yeah.
Do you ever think about how media or new media attention to your trials might impact your practice in terms of future opportunities for clients coming to you looking for business?
I think about that less than I should. My lack of financial success probably reflects that. But, you know, I can tell you this. Avery has brought me very little in the way of new business. You know, my referrals are still what they've always been, and not in the main from new sources. Although I had an experience in May that made me think about that, because I was giving a talk at a trial skills thing, and the person who introduced me was another criminal defense lawyer, and she hardly knew me, but she had a few minutes to try to decide what she was going to say to introduce me, and she didn't ask me. So she, you know, she did it on her own, and I was in the back of the room listening to the introduction. And what she chose to say is not, you know, Dean Strang's a real good lawyer, or, you know, I saw him do this, or whatever, or here's the things on his resume. What she chose to say was, you got to see this YouTube video of Dean Strang. That was really very striking to me. I don't think there is a YouTube video of Dean Strang. If there is, I wouldn't know how to find it or where it is. But that's what she thought was important. So, you know, using her as a potential surrogate for other lawyers who might refer a case to me or to any other lawyer, or the public, the educated public who might be casting about looking for a lawyer and not wanting to use the yellow pages. I don't know. You know, do they catch you on YouTube? That's a little scary.
Before we go, I just want, go ahead. Yeah.
Quick question.
Hmm.
Do you think the presence of the media would have a greater impact on the conduct of the court, on the conduct of the judge and the attorneys in the presence of the jury, or not in the presence of the jury? Do you think there'd be a difference in the conduct of the officers of the court?
My anecdotal experience is that the conduct of the officers of the court, the lawyers and the judge, rises across the board with intense media coverage. One man's anecdotal experience.
Whether in the presence of the jury or not?
Or not.
Before we go, I just wanted to ask you one question about something you just mentioned about your financial decisions in life, and you were a federal defender,
Mm-hmm.
and I think it's good for people who don't know that about you in this room to know that about you. What was it about that work that you felt was so important?
Almost everybody who goes through the criminal justice system in our states or in the federal courts is too poor to hire a lawyer. So if you care about criminal justice, you have to be concerned vitally with the experience of the person who's indigent. And the other thing that I think public defending did for me is help me to understand the different scales on which you find poverty. I tended, I think coming from a comfortable background as I did, to think of poverty in financial terms. Time spent public defending caused me to think of a whole matrix of impoverishment, impoverishment of a fund of general knowledge, impoverishment of emotional support, impoverishment of intellect, impoverishment of education, impoverishment of money, impoverishment of moral values or moral teaching, just a whole range of poverty that's very complex, it's intractable, and it is the core problem of criminal justice.
Mm-hmm. Well, we want to say thanks again for coming here. Actually, he's returning to the site of, you have some familiarity with this room, don't you? You taught a course in here?
Mm-hmm.
Was that true? How long ago was that?
Just two falls ago, so I hope to be back.
And you had a full room like this for your class?
I did not.
Anyhow, we want to say thank you to Dean Strang for being with us today. Thanks very much. Appreciate it.
Thank you. Thanks for having me.